Hello, my name is Rachel Rose, and I'm an attorney in Houston, Texas, where I have my own practice, Rachel V. Rose, Attorney at Law, PLLC. My practice areas focus on healthcare, cybersecurity, securities law, the False Claims Act, and Dodd-Frank from transactional compliance and litigation vantage points. I also have taught bioethics at Baylor College of Medicine for the past 9 years, and I'm extensively published and present on a variety of topics which are relevant to my practice. I've also had some significant cases where I've represented whistleblowers, which the government has intervened in, or where my co-counsel and I have moved forward without the government's intervention. Today, I'm here with Quimbee to discuss the False Claims Act, the basics, and then some. Now, no presentation is complete without a disclaimer. The information presented here today is not meant to constitute legal advice, so please consult an attorney for advice on a specific situation. Additionally, because of the dynamic nature of this area of the law, the information presented is current as of the initial date of this presentation, and participants are encouraged to check government websites, the SCOTUS website, as well as PACER and other relevant websites for the most up-to-date information. Today, we're here to learn about the following. First and foremost, appreciating the nuances of the False Claims Act. Next, appreciating the potential damages and what the recovery is for the government and a relator potentially, as well as the liability for the defense side. From there, I'll delve into the compliance standpoint and highlight some areas of interest to the government, and then we'll end with some trends in case law and conclude. So I wanted to begin with a snapshot of the Department of Justice. And the Department of Justice is often referred to as the largest law firm in the world, which actually began in 1789 as part of the Judiciary Act of 1789. At that time, there was the Attorney General and a single clerk. So basically, by 1870, the duties of the office of the Attorney General had expanded so much so that Congress adopted an act to establish the Department of Justice. Now, the Attorney General is the chief litigator and the chief law enforcement officer of the United States as the head of the Department of Justice. So let's fast forward from 1870 to 2021. And this is important because anyone practicing in this area of the law or considering practicing in this area of the law should do two things. First, if you've never brought a False Claims Act case, be sure to partner with seasoned counsel who has brought a False Claims Act case. There are a multitude of reasons, some of them procedural and some of them are not listed in either the False Claims Act text or in the Federal Rules of Civil Procedure expressly, but it is very important to appreciate that this is a very different statute and has nuances that can be costly for both counsel and the whistleblowers who, per the statute, are referred to as relators. Typically, I use those terms interchangeably. So if you hear me refer to whistleblower or relator as part of a key TAM provision in the False Claims Act, key TAM essentially means that a private individual has the ability, with the representation of a licensed attorney, to bring a case under the False Claims Act on behalf of the United States government. The United States government always remains the primary party of interest. And so, as we'll see in a few slides, whether or not the government intervenes or declines to intervene, the government always has the greatest share of the recovery, and nothing can get done without the government's blessing.